Hello everyone, and we are back with other topics to be covered this week. And this week, I'm going to start the topics of current legal issues and not the judgment summaries because we are doing it alternately. And I'm back with a bunch of topics. And today's topic is the Essential Defense Services Ordinance 2021. This Essential Defense Services Ordinance 2021 is regarding government's measure to bring down or muzzle the voices of dissent amongst the workers and employees of the ordnance factories or the people engaged in the defense manufacturing companies or defense manufacturing factories. Okay, usually what happens in a democracy, that every person has a right to freedom of speech and expression. And I have told you earlier also that freedom of speech and expression, yes, good afternoon everyone. Freedom of speech and expression is all about singing against the tunes of the government, is the real freedom of speech and expression. If you are expressing your dissent, 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 that is your disagreement. If you are protesting your disagreements, if you are getting your disagreements registered before the government, that what tells you the extent and depth of democracy. Okay, speaking was never disallowed. People used to speak in other forms of government also in ancient times, also in kingship and monarchy and dictatorship, but that speech was to sing along the tunes of the government, to agree what the government says. But democracy is against this. Democracy says that your freedom of speech and expression lies in expressing your dissent. Okay, if government says something, you are not necessarily supposed to believe it or agree to it. You have the liberty to disagree. Okay, protest is a form of disagreement that you can do. Okay, protesting before the government is something that democracy fully allows. Okay, but this Essential Defense Services Ordinance 2021 is a bit dangerous precedent for a democracy like us. Okay, because it prohibits the workers or employees of the ordnance factories. What are the ordnance factories? Ordnance factories are the factories which are engaged in manufacturing defense related products. Okay, so this Essential Defense Services Ordinance 2021 expressly prohibits the workers and employees of the ordnance factories to protest, or to say anything or to express their dissent against anything. So this article begins from here that protesting is never a disturbance of peace. Corruption, injustice, war, and intimidation are disturbances of the peace. Bryant McGill. Okay, on 30th June 2021, the President of India, in the exercise of his extraordinary legislative powers under Article 123 of the Constitution, promulgated the Essential Defense Services Ordinance 2021. Okay. Since the President of India has the power to promulgate any ordinance under Article 123 of the Constitution of India, so the present President of India, the current President of India, Shri Ramnath Kovind, he promulgated the Essential Defense Services. Yes, Taran Kapoor, it's the factories that produce the ammunition. Yes, right. So promulgated the Essential Defense Services Ordinance 2021. This ordinance essentially empowers the central government to prohibit any form of protest, such as strikes and lockouts and layoffs in essential defense services as defined under section 2(1) of the ordinance, as well as declare these acts as non-bailable and cognizable offences. Okay, so this is the first paragraph tells you the seriousness of the issue, that the ordinance essentially empowers the central government to prohibit any form of protest. Okay, the central government has literally prohibited any form of protest such as strikes and lockouts and layoffs in essential defense services, that whosoever is engaged or is included in the essential defense services, like within the in double inverted commas is essential defense services, as defined under section 2(1) of the constitution of the ordinance, as well as declare these acts as non-billable and cognizable offenses. Like if anyone from the essential defense services is protesting against the some policy or law of the government, he is going to face the music, and his act is going to be a non-bailable and a cognizable offense. So protest or such as holding strikes or lockouts in the factories, which is truly a democratic activity, has now been made a non-billable and cognizable offense by virtue of the Essential Defense Services Ordinance 2021. Okay, purportedly formulated to deal with the July 26 strike announced by the Employees Federation of the Ordnance Factories against the Union government's decision to corporatize the 41 ordnance factory boards, this temporary law tramples over the rights of workers and those concerned to hold peaceful protest, voice dissent, and form associations or unions. Okay, so protesting is a form of freedom of speech and expression. Okay, if you are forming associations or unions, that is also a freedom which is enshrined under Article 19(1)(c), I guess. Okay, you have Article 19(1)(a), 1(b), 1(c), 1(d), 1(e). All these freedoms, all these 6 freedoms under Article 19 of the Constitution, they expressly tell you that you have these democratic or basic fundamental rights, inalienable rights, that you can exercise freely in a democracy. Okay, so freedom to form associations or unions, this is also one of the freedoms under Article 19(1). Okay, and to express your dissent through these associations or unions is also a form of freedom of speech and expression. Okay, yes, Prableen, you have rightly commented Article 19(1)(a) and (b). Okay, so purportedly formulated to deal with July 26 strike announced by the Employees Federations of the Ordnance Factories against the Union government's decision to corporatize the 41 ordnance factory boards. This temporary law tramples over the rights of workers and those concerned to hold peaceful protest, voice dissent, and form associations or unions. Okay, so in this piece we shall briefly examine how the ordinance is expressly vague and expansive in its wordings, so much so that its effects are not limited to just the government employees in the concerned sector. Because this is a serious issue. Like, people in the ordnance sector, they have been completely prohibited or barred from voicing their dissent or forming any associations or unions. So all the present associations or unions which are working democratically have been held to be criminal, okay, or illegal. Okay, they have lost their authenticity, they have lost their legality, they have lost their constitutionality by virtue of this Essential Services Ordinance 2021. Okay, so this is a serious issue because this ordinance expressly stands in violation of various freedoms contained under Article 19(1) of the Constitution. Okay, so we will examine the unfettered powers it gives to the authority, significantly impacting the principles of natural justice along with the freedoms of the civil society and free press to comment or report on these strikes. Like, when people come out to hold a strike, then the media, the media amplifies their dissent. The media amplifies their voice to the entire country and to the entire nation. This is what media does. Because now this has been made a cognizable and non-bailable offense, the media would also withhold itself in future from commenting or reporting these strikes. So this is going to be a serious issue. Again, I'm reiterating this, that this is seriously a concerning issue. Now, what was the rationale behind the ordinance? Why the government thought of promulgating such an ordinance? This is the rationale explained. Okay. Preamble to the ordinance simply states that circumstances make it necessary to take immediate action. Nature of these circumstances have not been specified. The preamble of the ordinance simply says that, like every law has a preamble in the beginning, like the Indian Evidence Act, if you take out the Bayer Act, or if you read the Indian Contract Act, every statute begins with a preamble, okay, which is written right at the top, right in the beginning. Like if you have any bare text, you can see it. So every ordinance which is supposed to become the bill, and which is further supposed to become the law, begins with the preamble. Okay, so this preamble to the ordinance simply states that why this has been made. Make it necessary, like it is quoted here within double inverted commas, make it necessary to take immediate action. Like the government is trying to explain by writing this in the preamble to the ordinance, that it is the urgency, the circumstances create an urgency to bring these kind of ordinance, necessary to take immediate action. Nature of these circumstances has not been explained, like what circumstances here have been referred to. This is not at all clear. This is not at all clear that what kind of circumstances are being referred to here by the government. The government is simply saying that the circumstances are compelling us to take this immediate action. And these nature of these circumstances have not been specified. However, it may be reasoned that the clashes with China might have alerted the government, prompting it to take such precautions. One may even argue that Iron Shield is required to protect entities, be it private or public, to keep the defense supply chain inviolate. But the question would then arise how wide the meaning of such essential defense services should be. How wide? Like how far? It's going to cover the people involved in the ordnance factories. Like there are people who are engaged in the core defense sector. Then there are people who are engaged in the manufacturing sector, like defense manufacturing sector or the ordnance factories. And there are people who are supplying them the raw materials. Look, so how far this essential defense services, the phrase of essential defense services would expand to include how many people involved in the chain, because manufacturing is not an isolated activity. If an ordnance factory is involved in manufacturing defense products, then definitely it has to procure raw materials for manufacturing such defense products from somewhere and from someone. So the question, for example, right now here is that whether the essential defense services, the phrase essential defense services would expand itself to even include those who supply the raw materials to the manufacturers of the defense products, or anyone involved in the chain. So how wide the meaning of such essential defense services should be, because if the phrase essential defense services purports to include all those involved in the entire chain of manufacturing, reaching up to the core of the defense sector, then this Essential Defense Services Ordinance 2021 shall apply even to the people who like from where the entire chain begins. That is the question, from where the entire chain begins. Like any person who is involved in the chain, whether proximately or whether indirectly, okay. If this prohibition will extend even to those individuals or those people. Okay, so why does it coincide with the announcement of a strikes by ordnance factory workers? If the only intention is to deal with such a strikes, then why is the ambit so broad? If not, and it really is to deal with the border issues, why were such measures not taken last year when the situation was more heated? Keeping these potential reasons and questions in mind is very important while examining the need of this ordinance. Okay, so we have to dwell upon and find out that how wide is the ambit of the phrase essential defense services, like how far it includes the people. Then why does it coincide with the announcement of strikes by ordnance factory workers, like why the ordnance factory workers are protesting or they are reaching on strikes, and why this is coincidentally falling exactly at the same time when the factory workers, ordnance factory workers, are on strike. Okay, that is the question. Analyzing the phraseology. So Black's Law Dictionary defines vagueness as something which is indefinite. Now, Utkarsh is asking a question. Direct employees under those organizations which come under the Ministry of Defense. See, Utkarsh, direct employees are the people who are involved in the ordnance factories, like the workers, the employees of the factories, and the people involved in the defense sector, like the core of the defense sector. Okay, so they all come under the Ministry of Defense. Okay, but here the question is, if this ordinance is going to extend even to the people who are remotely connected with the defense sector, who are not directly connected with the defense sector. For example, you are manufacturing a defense product and I am supplying you the raw material. Like I am the supplier of the raw material, I supply my raw material to various other private industries also. But I am also supplying my raw material to you. Then the question, like I am just illustrating a point. This is not the situation exactly what I am telling you. What I am exemplifying is not exactly what is written here. I'm just illustrating a situation to make you explain this. Okay. I'm supplying my raw material to you also. The question is whether the supplier of the raw material, like me, who usually supplies the raw materials to various other industries, is also involved in the essential defense sector or not. Like, because I'm remotely connected with the defense sector, I'm not the immediate employee. I'm not the person who is proximately connected with the defense sector. I am remotely connected with it because I am simply supplying the raw material. The question is whether the ambit of this phrase called the essential defense services would extend to even include me also or not. That is the question. Ministry of Defense has nothing to do here. The question is to understand the width and length of the ambit of the phrase essential defense services, to understand how far this applies to different people, how far this ordinance applies to different people. Okay, so Black's Law Dictionary defines vagueness as something which is indefinite. The Indian Supreme Court has stated that prohibitive laws are said to be vague when prohibitions are so prescribed are imprecise, and those who face deprivation of rights should know the precise extent of such deprivation. Furthermore, laws should not delegate blank space for subjectiveness to be applied by policemen or judges on ad hoc basis, leading to arbitrariness and discrimination. Okay. Like, for example, when and how do you call something as vague? What is vagueness? When the things are not clear, when there is a cloud of ambiguity that is hovering over something, then that is called vague. Then that is called vague or indefinite. You do not have a concrete conception of something. The idea will be said to be vague. Okay, so the Indian Supreme Court has stated that prohibitive laws are said to be vague when prohibitions so prescribed are imprecise, and those who face deprivation of rights should know the precise extent of such deprivation. Like, for example, I should know how far I can exercise my freedom of dissent. If, for example, while exercising my freedom of dissent, I may enter into the boundaries of sedition also. So, as a responsible and a learned citizen of my country, I should know the extent of my freedom of speech and expression so that I may exercise it in the limited boundary. I should not encroach or enter into the domain of sedition, because there is a very thin line of difference between freedom of speech and expression and the act of sedition. Okay, so we have to know the precise extent of such deprivation. This ordinance comes with a prohibition which is very vague. The concern here is, the main point of discussion here is that this ordinance comes with a prohibition which is very vague, which is not clear. Like, it does not lay down the precise extent of such deprivation, that how far the workers of the defense services are deprived of their right to freedom of speech and expression, or right to hold or go on strikes. Okay, so there is like, furthermore, law should not delegate blank space for subjectiveness to be applied by policemen or judges on ad hoc basis. Like, policemen or judges will then be left to apply and interpret this blank spaces, that whether they are included or not. This should be very clear. So this leads to arbitrariness and discrimination also. So vagueness in phraseology and consequent expansiveness of this ambit of relevant legislation or laws has become a trademark for many of the recent laws, rules made by the Union government, be it the recent amendment in the Unlawful Activities Prevention Act or the newly issued Information Technology Rules 2021. So the writer is trying to is making a calibrated attack on various recent amendments also, in the backdrop of vagueness, because vagueness, these recent amendments were also marked by a lot of vagueness. Okay, the ordinance seems to be another such piece of legislation. It can be said so because under section 2A, now this is very important, read this line very carefully. I'm reading it and just listen to me very carefully. Under section 2A of the ordinance, essential defense services are defined as 1. Any establishment or undertaking dealing with production of goods or equipment required for defense related purposes, or 2. Any establishment of the armed forces or defense. 3rd, or any establishment connected with defense on the working of which safety of such establishment or employee depends. Okay. So any establishment or undertaking dealing with production of goods or equipment required for defense related purposes. Like production of goods, or any establishment, any person who has an establishment which is involved in the production of goods or equipments which are required for defense related purposes, or any establishment of the armed forces or defense, or any establishment connected with the defense on the working of which safety of such establishment or employee depends. Like anyone, any establishment which is connected with the defense services or the defense factor, जिसके ऊपर पूरी की पूरी वर्किंग निर्भर करती है. अब ये जो फ्रेज है ना कि कोई भी एस्टैब्लिशमेंट, एनी एस्टैब्लिशमेंट जो भी डिफेंस से कनेक्टेड है, जिसके ऊपर पूरी उसकी वर्किंग या एम्प्लॉइज डिपेंड है या निर्भर करते हैं, ये भी इन्वॉल्व है एसेंशियल डिफेंस सर्विसेज में. नाउ I assume that you must have realized the vagueness involved here. Like this simply says that any establishment which is connected, which is connected with the defense on the working of which safety of such establishment or employee depends. So this is very ambiguous. This phrase, this line is very ambiguous and very vague and does not clearly tell us. It does not clearly tell us that how far this establishment, like how far this goes. Okay, working of which, safety of which such establishment or employee depends. अब for example मैंने जो आपको illustration दिया था, the illustration that I gave you was like I am the supplier of raw materials. I am no one. I am simply supplying raw materials to an ordnance factories. So the manufacturing and production of defense goods or equipments depends on the supply of raw materials which I supply to them. But I am not the part of defense sector. But this law says that if the manufacturing or production depends upon something, then this is a question to be mooted upon, that whether a person like me would be included in the essential defense services or not. So this is the vagueness that is involved here. Are you getting my point? Are you people getting my point and understanding what I am trying to convey? Okay, Nikhil. Nikhil has understood. So that's what I'm trying to explain, that things are not clear here. They're ambiguous, they're doubtful. In addition, now read this line. In addition, the government may declare any service as an essential defense service if its cessation would affect the production, operation, maintenance, and repair of defense equipments or goods. Like the same illustration, I'm using it as a crutch today. That if I stop supplying my raw material, then this will like seize the production of the ordnance factories, right? So applying that logic, I should be a part of essential defense services then, because if I stop supplying my raw materials, this will then seize the production, operation, maintenance, and repair of defense equipments or goods. So applying that logic, I may be included in the essential defense services, but still I would say that the language is very vague and doubtful. Okay. Ananya Das is not understanding, I guess. She is a bit confused. Tell me, what confusion are you encountering? See, Utkarsh is commenting. Let's read your comment first. The 2A third point is only talking about establishments working on safety of employees or establishment and nothing else. And the example you are giving, sir, is related to production and not safety. I told you in the beginning that you have to take my illustration as illustration only. Do not try to fix it do not try to fix my illustration what is exactly written here. Any establishment connected with defense, on the working of which safety of such establishment or employee depends. Exactly, that can be the point. But read the other line also, that the government has already taken this discretion under this ordinance to declare any service or to declare any services essential defense services upon which the production, operation, maintenance and repair of such defense equipments depends. That is why I am giving you this example, that it's not only about safety, it's also about the production. The government, if the government is taking this discretion or this prerogative on its own shoulders to declare any service as an essential defense services, if the cessation of which would affect the production, operation, maintenance and repair of defense equipments or goods, then this is something which is creating vagueness. Okay, are you trying to understand what I am trying to say? Okay, so far as safety is concerned, for example, if some private agency is supplying, now listen to my illustration very carefully. If some private agency is supplying fire extinguishers to the ordnance factories, like this illustration can be taken as a safety. This illustration can be taken as from the point of view of safety. If Utkarsh, you are talking about the point of safety, now listen to this illustration. If, like for example, my grandfather, after his retirement from the post of Deputy Director Police Fire Service UP, he started his own private agency which he used to supply fire extinguishers to various establishments. Since it is mandatory under law for every institution or agency to fix a given number of fire extinguishers in their offices. So every time our agency used to supply them the fire extinguishers. Okay. Fire extinguishers. Prableen, I will come to your question after I finish this. Okay. Now, for example, if my private agency is supplying fire extinguishers to an ordnance factory, because this is something where the safety of the employees depends. Okay, and if I, for example, stop supplying them, or if, for example, if I'm not even if I don't even stop supplying my fire extinguishers and I'm supplying them, will then my agency or me will be included in the essential defense services or not? I'm a private agency. I'm a private individual who owns a private agency which supplies fire extinguishers and supplying them to an ordnance factory. Then tell me, according to this definition, whether should my agency or I be included in the essential defense services or not? Prableen is commenting, if no raw materials is provided, then the establishment will not be able to produce the ammunitions, which will somewhere affect the safety of the other establishments of defense dependent on it. Not exactly, Prableen. It will not affect the safety, but rather it will directly affect the production. And that's what the next line says. See, read this line. What is written in italics stops here, and once this read from here, in addition, the government may declare any service as an essential defense service if its cessation would affect the production, operation, maintenance and repair of defense equipments or goods. And so far as Utkarsh comments was concerned, I was explaining and illustrating his point from this example, that even if I provide a safety equipment like fire extinguisher, being a private agency, will I be then included in the essential defense services definition or not? That was the question. Okay, so this is where I will be left unanswered because the ordinance is silent here. Ordinance is silent here. Okay. This has been left to be interpreted by the policeman or the judges. This is what the writer says. That this is what the writer says that these kinds of gaps, these kinds of vagueness are to be left to be interpreted by the police personnel or by the judges. Like in the end, the judges will then have to clarify it and interpret it whether these kind of people will be included in the definition of essential defense services or not. Right. So that is the question here. I hope, Utkarsh, you have understood. Have you understood? Utkarsh is commenting should be included but very remotely connected. That is what the vagueness is, Utkarsh. That is what I am asking you to understand. That I am remotely connected with it, but I am still like I do not have a concrete answer. I do not have a clear answer whether will I be included in this or not. So this is what the vagueness is. The writer is talking about this ambiguity. Under section 2b, now let me proceed. Under section 2b, strike includes all forms of protest possible, such as sit-ins, cessation of work, casual leave, and even token strikes, etc. Any form of organized action and even the refusal to do overtime can be prohibited under section 3 by a notification for 6 months, which can be further extended. All these actions are punishable with 1 year of imprisonment or 10,000 rupees fines under section 6. Similar punishments for lockouts have also been provided under section 9 clause 5. See, people have been barred from protesting, and strikes would include sit-ins if the workers stop working or they go on a casual leave, or even the token strikes. And for example, if there is any organized action from the workers or the union of the workers or their association or if they are refusing to do overtime. So this refusal can also be prohibited by the government under section 3 by a notification for 6 months, and which can further be extended by the government. So the government is reserving all these powers with itself under the ordinance, that we can prohibit you from going on strikes, we can prohibit it, we can load you with overtime work and still you cannot refuse. So these kinds of things are made punishable with 1 year of imprisonment or 10,000 rupees fines under section 6. And similar punishments have also been provided for lockouts under section 9(5). Therefore, due to the repeated use of any and due to the power, the word any has been used so many times that it's a repeated use, and due to the power given the central government to declare any other service as it sees fit to be an essential service under section 21A(4) of the ordinance, no distinction can rightly be drawn between the private companies and their employee on one hand and the government sector undertakings on the other. Okay, Ankita is asking, can authorities under defense services strike, and for what? They can strike for putting their demands. Like if their demands, their working hours or their working conditions, it can be related to anything. They can protest. They have a democratic right. Every government employee or private employee has a right to go on a strike and protest. But this ordinance is making it punishable for the workers of the ordnance factories. That is simple, Ankita. Okay. Therefore, due to the repeated use of any and due to the power given to the central government to declare any other service as it sees fit to be an essential service under section 21A(4) of the ordinance, no distinction can rightly be drawn between the private companies and their employee on one hand and the government sector undertakings on the other. The definition also does not distinguish between large factories, building tanks, and the small, medium-sized businesses providing goods or services such as boots, raw materials, repair, etc. Thus, allowing the government to not only dictate the employee in the public sector undertakings, but by extension also impact the ability of the employees in the MSME sectors to protest against the working conditions, thus adversely impacting the rights of every employee and worker men involved in the defense sector. Impact on the private sector will be further dealt with in the next section. जो मैंने आपको इलस्ट्रेशन दिया, एग्जैक्टली ये वही बात कर रहे हैं कि it is going to indirectly affect the people in the MSME sectors also. Like if I own a mini enterprise and I am remotely connected with the defense services, and if I stop supplying my raw material, or if I stop supplying my fire extinguishers, for example, which is good from the point of view of safety, then in that case, will I then be included in the essential defense services? Will I then have to face the punishment? Okay. Will I be said to commit a non-billable and cognizable offense? That is the question, right? So this is going to create a chain of effects, impact on the private sector. Apart from Tata, Mahindra, Reliance and other giants that supply equipments to the armed forces regularly, the defense supply chain also involves about 24,000 MSMEs, and these companies employ millions of workers. Okay, defense supply chain. As noted above, the ordinance will not only impact government facilities, but even private sector employers can put their workers under inhumane working conditions under the guise of keeping the defense supply chain intact. Like for example, the government is keeping the workers under inhumane working conditions. Should not then, do you think, the workers go on a strike? What do you think? Should not the workers go on a strike and demand better and humane working conditions for themselves? But if they do so after this ordinance comes into effect, if they do so, they will have to face the punishment because they will be said to commit a non-billable and cognizable offense. Are you trying to understand? Simply. Okay. And for example, if I am not getting my remuneration, I am supplying raw materials, I am supplying fire extinguishers, and I am not getting satisfactory remuneration for my services, I will then stop supplying these kinds of things to them. What will then happen? Will I go to jail for protesting? Will I then have to face the music for not supplying or continuing with the agreement? Okay, that is the question. As noted above, the ordinance will not only impact government facilities, but even private sector employees can put their workers under inhumane working conditions under the guise of keeping the defense supply chain intact, that too with the backing of the state. Hence, the ordinance is a surgical strike over the rights of all the civil defense workers employed in the private sector. As mentioned above, almost all forms of mass action pressure tactics are included under the ambit of a strike and thus can be prohibited. The ordinance even allows the management authorities under section 5(1) to take any disciplinary action, including dismissal against the workers who may be found to take part in or instigate prohibited strikes. See, this is very clearly written. You can understand. The problem becomes worse as section 5(2) lays down that notwithstanding any other law, like notwithstanding, चाहे किसी बाकी law में कुछ भी लिखा हुआ हो, notwithstanding any other law, this is a non-obstant clause. The authority concerned may take such action without any proper inquiry if the authority concerned is satisfied that holding a proper inquiry is not reasonably practicable by just recording this reason in writing. So the government is so powerful, has been made so powerful, like unfettered power, The ordinance is giving the government unfettered power to prohibit any kind of a strike, to send any worker in jail if he is found to have included or instigated any prohibited strike. He will simply go to jail without, or he will simply go to jail, or he can even face dismissal, and he can, like, no proper inquiry will be established, no prior for departmental inquiry will be established. He will simply go to jail because the government will think that this is not reasonably practicable. Okay, so ironically, the ordinance may even prove to be detrimental to the interest of the employees in the private sector. Under Section 10, the government has been empowered to bar the employers in these services from laying off workmen as it sees fit via an issuing notification. The only two exceptions provided are natural calamity and power shortage. Like, for example, if there is a power shortage and there is any natural calamity and the work cannot be carried out, only then the workmen will be like can be excused. Apart from these two exceptions, apart from these two reasons, there is no other third reason for which workers can stop their work. As the ordinance has been promulgated during the COVID-19 crisis, it can be implied that COVID-19 is not included in the national calamity. Furthermore, no declaration by the central government has been provided in such regard. Thus, the economic crisis inflicted due to lockdown cannot be used as a pretext to lay off workers once the notification has been issued by the government. Therefore, we can say that vagueness and the over-intrusive language of the ordinance has provided the government with powers that can prove to be rather dangerous. So have you understood? Riddhi is asking, is it useful for judiciary also? Anything which falls, I'm going to give you a vague answer now, Riddhi, that anything that falls in the category of current legal issue is important. Okay, for judiciary. Since this is the most recent thing, recent current issue, legal issue, then you can take it as important thing for judiciary also. Other questionable provisions. Apart from the direct assault over rights, apart from the direct assault over rights, the ordinance seems to be having a more insidious intent of breaking the back of collective struggle, as well as the power of the press to critically report on the action of the authorities with regard to these services. This understanding roots from the reading of Section 7, which provides for 1.5 years of jail and or 15,000 rupees as fine if any person is found inciting or instigating any other person to take part in the strike prohibited by the government. You can read the quantum of punishment is written here, the amount of fine is written here, anything is written there, simply for inciting or instigating any other person to take part in the strike prohibited by the government. Like if we two are working as workers and you are my co-worker in a factory and I ask you to go on a strike for demanding better working conditions for us, then this will not be an innocent activity. This is going to be a bailable and non-cognizable offense. I will have to face the quantum of punishment then, which is written here. Okay. Furthermore, those who are found funding such strikes can be imprisoned for 2 years and or suffer a fine of 20,000 rupees under Section 8. The use of police force has been authorized under Section 4. The police do not even require an arrest warrant to carry out such detentions as per Section 11 of the ordinance, notwithstanding anything mentioned in the CRPC 1973. Now you can understand how dangerous it is. Okay, the police force has been authorized under Section 4. The police does not require any prior arrest warrant to carry out such detentions as per Section 11. And whatsoever is written on the in the CRPC 1973 will not apply, because this is a non-obstant clause and this shall prevail over whatever is written in the CRPC 1973. Further, all the offences are non-bailable and cognizable offences. Surely, the Industrial Disputes Act 1947 also provided under Section 27 imprisonment for 6 months and a fine of 1,000 rupees. But here, as noted above, the punishment is much worse. The fact that instigation and incitement have not been defined, nor has the ambit been limited to a particular group of people, gives the impression that even publishing content sympathetic to the cause of the employees or justifying their actions can give rise to grounds for application of this penal provisions. This ordinance also does not define any what is instigation and what is incitement. Like if the government simply says that you have committed an instigation or that you have incited the strike, then you will have to buy that argument, because instigation and incitement are nowhere defined. And even this ordinance does not say that the instigation and incitement as defined in the IPC would be taken as defined under IPC. Okay. Further, the workers' union all around India share funds and provide moral support to each other by penalizing sharing of funds. The government is targeting the rights of the employees to form unions and provide aid to their brethren. Only procedural safeguards as per section 18 is that every notification issued has to be tabled in both houses of parliament for approval and modification if any. बस इतना सा रहम किया है कि कोई भी नोटिफिकेशन इशू होने से पहले वो नोटिफिकेशन दोनों हाउसेस ऑफ पार्लियामेंट में टेबल किया जाएगा. That's it. However, even this sounds hollow because Parliament not giving its approval will not invalidate any order passed under the notification. An operation with constitutional backing under Article 19(1)(b) provides all citizens the fundamental right of freedom of to assemble peaceably without arms. 19(3) empowers the state to curtail our freedom to assemble peaceably for any purpose including protest. No mention of grounds such as public interest, decency, morality, or defense of any state finds mention in the article. However, the ordinance specifies that a notification prohibiting strikes or lockouts can be issued on the grounds of public interest, decency, morality, or defense of any state along with sovereignty and integrity of India or public order under section 3 and 9 respectively. Even if we take into account the grounds for restricting freedom of speech and expression provided under Article 19(2), public interest finds no mention there also. So whatever the reasonable restrictions are listed under Article 19(2), 19(3), they are not even expressly mentioned here in the ordinance that we are using those reasonable restrictions to prohibit these kinds of strikes and democratic protest. No, this is simply prohibiting them directly. Like there is a lot of absurdity involved in the ordinance. Okay. Public interest again has been left completely undefined under the ordinance, leaving it completely at the satisfaction of the central government. Like it's going to be completely the prerogative of the central government to define what is public interest. If the central government says it is public interest, then that is going to be a public interest. That's it. It is completely left to the satisfaction of the central government. What is even more surprising, however, is that such legislation can hardly be questioned in our constitutional courts on the above mentioned basis, since the Supreme Court has historically, as shown below, distinguished the right to assemble from the right to hold a strike against the employers, and because the right to hold a strike recognized under the Industrial Disputes Act, albeit with restrictions, has been overridden by the non-obstant clause under section 16 of the ordinance. See, I told you, the non-obstant clause overrides everything. And this ordinance comes with a lot of non-obstant clause. Even this is said to override the provisions of the CRPC 1973. Utkarsh is asking, is there a bar on resignation from the job? So far as I have not come across any such provision. Let's see. But I don't think so. ऐसा नहीं है उत्कर्ष, रिजाइन तो कभी भी कर सकते हैं. ओके It was while examining a similar prohibitive ordinance called the Essential Services Maintenance Ordinance 1960, which prohibited strikes in services like post and telegraph, etc. Listen, now read this very carefully. What happened when Essential Services Maintenance Ordinance 1960 was brought to prohibit strikes in services like post and telegraph? The Supreme Court in Radhe Shyam Sharma versus Postmaster General held that such laws are essential and cannot be seen as violative of fundamental rights or freedoms provided in the Constitution. It also stated in pursuance of All India Bank Employees Association versus National Industrial Tribunal that there is no such right called right to strike under our constitution, and it has no relevance with regard to Article 19(1)(b). The court in the case of T.K. Rangarajan versus Government of Tamil Nadu went ahead to remark that a strike offended the fundamental rights of the masses. This unsympathetic reading of rights, partly to ensure non-disruption of business and commercial interest, has left the worker and employees at large with little to no recourse against laws and orders which can prove to be blatantly against their interest. Perhaps this is a field of constitutional law that requires the more accommodative review and certainly more discussion amongst the people of civil society at large. However, as noted above, the vagueness in wording of the Act Ankita is commenting something. You are teaching all subjects of legal affairs, but the syllabus which not in CLAT can come in exam means subjects. What are you trying to say, Ankita? Are you trying to say that I am not covering the topics which are supposed to come in your CLAT exam? Seriously? Are you telling me that? Then provide me a list of topics. Okay. Taran Kapoor is asking if a bar to resign from the establishment if a bar to resign from the establishment finds place in the ordinance, then it becomes violative of Article 19(1)(g). Yes, exactly, Taran. Okay. Exactly, that you are right. It is violative of Article 19(1)(g). Okay. No matter what the Supreme Court has observed so far in various cases, but right to strike is a form of protest which is very democratic and very constitutional. Below the shadow of Article 19(1)(a) of the Constitution. Similarly, the freedom to resign or to do any or to carry out any job, if there is a bar or prohibition on such kind of thing, this is going to be violative of Article 19(1)(g). However, as noted above, the vagueness and wording of the Act would possibly make it liable of infringing Article 14 of the Constitution. The Supreme Court has also struck down Section 66A of the IT Act on similar grounds. A contention can also be raised under Article 21 of the Constitution as it affects livelihood of many individuals, but that aspect has not been discussed here. Conclusion. Through the means of this article, the author has tried to shed light over the controversial ordinance related to defense production. For this purpose, we have briefly examined the vagueness and phraseology of the said ordinance, its impact on private sector, and other relatively oppressive provisions. The aim has been to shed light over the shrinking protest and the need to re-examine the jurisprudence related to strikes in the Supreme Court. Okay. There is little to no doubt in the fact that India is going through a significant defense crisis on our northern borders, and keeping the supply chains intact thus has become a necessity. However, via this ordinance, the government has taken the path of confrontation over conciliation. It does not only infringe upon some of the basic rights of the various kinds of labor, but also antagonizes the defense community as a whole. So this was all about this ordinance, Essential Defense Services Ordinance 2021. Now, if your questions are most welcome. Utkarsh is asking if there is a crisis on the northern region, why to break the OFB? What is OFB, Utkarsh? What is OFB and make PSUs when we had a government establishment? I'm not getting your question. Please elaborate. Ordnance Factory Board. Okay, okay, okay. Ordnance Factory Board and make PSUs when we had a government establishment. See, the government is very desperate to disinvest and corporatize every institution, like it conducted 100% disinvestment in Air India recently. So the government is of a capitalist nature. This present government is of capitalist nature and is trying to privatize everything. So that is why they are trying to corporatize industry every industry right now. So अभी PSUs में भी disinvestments शुरू हो जाएंगे. Okay, I guess that's what you are asking. Ananya is asking me to give a short summary of this ordinance. This ordinance, Ananya, is all about prohibiting the rights of workers involved in the defense sector, whether production, manufacturing, or anything, that they do not have them, they no more have the freedom to express their dissent or go on a strike. Okay, they do not have this liberty anymore to go on a strike. ओके, और अगर कोई प्रोटेस्ट पर जाता है देन उसको पनिशमेंट मिलेगी. ही और शी विल हैव टू फेस द पनिशमेंट. Taran Kapoor is asking, sir, but irrespective. What, Taran? Questions? Any more questions? Taran Kapoor, you are commenting, but irrespective of whether government disinvests in PSUs and make them fall under the umbrella of private sector, still they'll be treated as part of the state. See, this is a very typical question which needs to be answered by the Supreme Court. Already, the Supreme Court has laid down certain parameters for deciding whether an organization falls under the definition of state under Article 12 or not. You look at those parameters, but perhaps so far as my understanding goes, this will not be included in the definition of a state if they are 100%, if there is an 100% disinvestment in any PSU, they will not be included in the state, because if more than half of the shareholdings is belongs to the government only, then an organization has to be treated as a state, otherwise not. Okay. And if they are almost fully privatized, then they are not going to be treated as a state unless the administration or its regulation is within the hands of the state. Perhaps. PSUs are the entities that work on behalf of the government, but once they are fully privatized and no their regulations or their regulation or administration and their shareholding no more belongs to the government, they cannot be included in the definition of a state. Okay. Ankita is commenting that there was a para on POXO Act, then we will have to learn all sections of POXO also. No, not necessary, Ankita. Anything else? Okay, then I am ending the stream now. Let's meet tomorrow. Till then, all the very best and bye bye.